Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. One topic that keeps coming up in suggestions is people wanting me to talk about Freeman on the land and other pseudo-legal theories. Now, properly, the case to cover would be Meads and Meads, but that clocks in at 188 pages, which would mean something like a 6-hour-long epic. I don't think a whole lot of people have time for that. So I've been keeping an eye out for a case that really sort of covers some of the issues and maybe is a little punchier. And I think I've found one. It's the case of the Queen and Matthew Duncan. It's got everything I was sort of looking for here. It's short, it's at 12 pages, it's funny, and it covers some of the issues. So let's dive in and have a look at this, and we can talk a little bit about the larger issues here. So as mentioned, the Queen and Matthew Duncan. And this is a case from 2013. So it begins, overview. You should get out of town, the man said. And so began the journey that resulted in my path intersecting with Matthew Duncan's path, and thence to these reasons with a slight detour through territory that might have confused Lewis Carroll. This one's going to be a fun one, I think. I suppose that I should clarify that there was no menace in the man's directive to me to get out of town. He was a friend and a colleague in 2 careers. His suggestion had been that he and I should change positions for a fortnight, giving him exposure to the realities of the northern reaches of Toronto, while I would enjoy a similar change of environment in the more sylvan environs of Niagara region. I might even see a few plays in the evenings, he pointed out. So what he means here is that this is somebody who he probably worked with as a lawyer and then later as a judge. They're both judges. He normally works in Toronto, and he's trading places with somebody who works, a judge who does the out-of-town circuit. So they've done a swap here. But I do love the flowery language on this one. It's clear that the judge is having a bit of fun, or the justice, rather. And thus I came to meet Mr. Duncan. At heart, Mr. Duncan's case was unremarkable. A minor alleged Highway Traffic Act offense led to a police-citizen interaction in the parking lot of Mr. Duncan's apartment building in the wee hours of the morning. A request that Mr. Duncan produce his license led to an alleged refusal, which led to an attempt to arrest him, which led to a struggle, which was captured on a very poor quality video taken on a mobile phone, at the end of which Mr. Duncan found himself being placed under arrest for allegedly assaulting a police officer. Nothing unusual in all that. The bread and butter of provincial court. Of course, I hadn't counted on the Freeman of the land. Mr. Duncan was self-represented. Other than a mildly annoying disinclination on his part to stand when addressing the court, although he did stand when questioning witnesses, he was a rather pleasant young man. Unfortunately, he was a rather pleasant young man whose mind was filled with what my late father would have called notions. And then there's a footnote. So I kind of feel that this justice might have been inspired by the spirit of Terry Pratchett here, who also loved the footnote, because this is a fun case, as I mentioned. So the footnote, I should point out that Mr. Duncan preferred not to be called Mr. Duncan, but rather Matthew. There was some mumbo-jumbo about the natural person and the administrator, and that one of them might have been Mr. Duncan, and one might have been Matthew, and one, but not both, of them might have been the persons speaking to me in court while seated. However, when I read the affidavit of truth presented to me by Mr. Duncan, I noted that it had been sworn by someone whose first name was clearly Matthew, and whose second name looked very much like Duncan, and certainly began with a D and a U. Since Mr. Duncan agreed that the affidavit had been sworn by him, and accepted my proposition that there is no D and no U in the name Matthew, I continued to refer to him as Mr. Duncan through the proceedings. This sort of argument is very common with Freeman on the land and similar types, where they will say, oh, this name refers to me, and this other name refers to this imaginary entity. And the courts don't typically have a whole lot of time for it, but people keep trying it. So that's sort of what's going on there, is this whole argument around, oh, it's not me, it's the corporate person and the all of which is just gibberish. So it has been said that given enough time, 10,000 monkeys with typewriters would probably eventually replicate the collected works of William Shakespeare. Sadly, when human beings are let loose with computers and internet access, their work product does not necessarily compare favorably to the aforementioned monkeys with typewriters. And there's another footnote here for monkeys with typewriters. For readers under the age of 30 or so, the typewriter was a mechanical device used for creating documents that predated the computer and lacked some of the computer's more annoying characteristics, in particular, the computer's facilitation of cutting and pasting, which is undoubtedly one of the four horsemen of the modern apocalypse, and which has cost many trees their lives and many lawyers and judges their eyesight. I'm amused. And there's a couple more footnotes here. So the first is on William Shakespeare. William Shakespeare was a 16th century English poet and playwright of some skill. He's remarkable insofar as he and Joseph Conrad are among the very few English language authors of particular merit who are not either Irish or Scottish. And there's a footnote for the Internet. The Internet, also known as the World Wide Web, is a bipolar electronic leviathan that has erupted on the world scene in the past 2 decades. In its benevolent manifestations, it has enormously increased and expedited access to useful information of all sorts, increased global awareness of myriad events, facilitated family and commercial communication across national boundaries in the blink of an eye, and helped topple dictators. It is probably fair to say that its advent is of no less significance than the invention of the printing press. However, just as the printing press has been put to odious use from time to time, the Internet has its own Jekyll and Hyde nature. It is a near certainty that future generations will look back at these decades, obsessed as we were with the twin behemoths of reality television and the "ooh, look at me, I must tell the world what I had for breakfast" narcissism of social media, and at the billions of hours thus lost to a near psychotropic electronic escape from any useful pursuit, and wonder if Aldous Huxley only got a few details wrong in Brave New World. For the purposes of this case, the relevance of the Internet is its unpoliced garbage in, garbage out potential, and its free market of ideas potential to lure in otherwise pleasant and unsuspecting folk with all manner of absurdity and silliness. And one more footnote. Lest anyone misunderstand me, this is by no means intended to compare Mr. Duncan to a monkey. As I've noted, Mr. Duncan seemed a decent fellow who expressed himself well, other than rambling a bit too long about jurisdiction, as noted herein, and whose principal shortcomings appeared to be too much free time with Internet access and too little discernment in whose example he followed. The reference to monkeys with typewriters is intended solely to point out that technological advances are sometimes used to such ends that one wonders if perhaps the Luddites didn't have a point. I kind of appreciate the sense of humor on this one. So continuing on. Thus it was that the trial began with Mr. Duncan objecting to us proceeding on the basis that I had no jurisdiction over him. Mr. Duncan provided me with an affidavit of truth, a rather substantial volume that appeared to me to be the result of someone doing a Google search for terms like jurisdiction and the like, and then cobbling them together in such a way that it makes James Joyce's Ulysses may look like an easy read. This hodgepodge of irrelevancies relied upon by Mr. Duncan was one of the misbegotten fruits of the Internet. Finding it was a waste of Mr. Duncan's time, printing it was a waste of trees, and my reading it was a waste of my time and public money. With that volume as his starting point, Mr. Duncan spent some time explaining to me that I had no jurisdiction to try him, that he was not a citizen of the province or the country, that he was not a person as defined by my definitions, and that there was no contract between him and me to give me status to sit in judgment over him, and so on. As I've said, Mr. Duncan struck me as a perfectly pleasant young man, but on this issue he seemed a bit obtuse. I suppose that if perfectly pleasant young men weren't led astray from time to time by drugs, alcohol, broken hearts, or rubbish on the Internet, then the dockets of provincial court wouldn't be quite as plump as they usually are. Now, let's sort of break down what's going on here. Freeman on the land have various, and there's different varieties of this kind of thinking, but they tend to make arguments, including this sort of very common one. You know, the court doesn't have jurisdiction because I'm the natural person and not, and there's all sorts of different flavors of it. But the court here is basically dismissing them and pointing out that this is kind of hilarious. So these are not arguments that the court is going to take seriously. And in fact, when they take things more seriously, it's typically to do so in an angry fashion. It's typically to punish people for bringing that sort of garbage to the court. This is actually quite a lighthearted and friendly way, but it puts no weight. It doesn't lend any credibility to these arguments. It basically says, why did you bring us this garbage? So the evidence. After much toing and froing about jurisdiction, either Mr. Duncan or Matthew or his administrator, I never was quite sure which, they were all talking through the same corporeal form, entered a plea of not guilty on Mr. Duncan's behalf, and we proceeded to the evidence. So that whole jurisdiction argument got them nowhere. The Crown's first witness was Constable Paul Ellis, a relatively junior member of the Niagara Regional Police Service and the alleged victim of the assault to resist arrest. Constable Ellis testified that on the night of 1-2 December 2011, he and his partner, or I guess that's the first and second, he and his partner, Constable Pilkington, were on uniform patrol in Grimsby at 2:48 a.m. when they saw a car driven by Mr. Duncan make a right turn onto Slessor Boulevard in Grimsby without signaling the turn. The car then pulled into the parking lot of an apartment building on Slessor, where Mr. Duncan lived, and the police car pulled in after Mr. Duncan's car. Mr. Duncan and Constable Ellis got out of their cars, and Constable Ellis asked Mr. Duncan for his identification, specifically a driver's license. Later, in response to a rather leading question on a highly material point, Constable Ellis said that he also asked for even a verbal identification. I think that's a mild criticism of the Crown, because I can't imagine who else would have led this witness. Certainly, Mr. Duncan in cross-examination would have been entitled to ask leading questions, and no criticism should follow for that. So I suspect that this was him saying, Crown, come on, you can't feed the guy the answer. So he said that he and Constable Pilkington repeatedly asked for identification and warned Mr. Duncan that he would be arrested if he failed to do so. At some point in this interaction, Constable Ellis said that Mr. Duncan pulled out a red binder and told Constable Ellis that he would be giving him a fee schedule. He told the officers that they had no jurisdiction over him and accordingly had no authority to arrest him. Now, this fee schedule thing is another sort of real common argument where they'll say, oh, look, I'm going to present you with this list of charges. And typically they're these ridiculous amounts. It's like, if you continue to bother me, it's going to be $10,000 if you arrest me. It's going to be $1 million for every day that I'm held in custody. None of which gets them anywhere, but it's a very common strategy. If you ever see anything online where they say, oh, and then you can present them with your fee schedule, it's bunk, and it never works. It never gets anybody anything. As far as I know, nobody has ever been paid out as a result of one of these fee schedules, but people keep trying it. So he told the officers that they had no jurisdiction over him and accordingly had no authority to arrest him. Spoiler alert. Well, that one's kind of mixed. We'll get to that. Constable Ellis then told him that he was under arrest for failure to identify under the Highway Traffic Act. Mr. Duncan then allegedly pulled away from Constable Ellis's effort to grab his arm and started walking toward the apartment building. Constable Ellis repeatedly told him to put his hands behind his back and stop resisting arrest, but Mr. Duncan put his hands to his front instead. A struggle ensued, with Mr. Duncan ultimately being subdued and handcuffed about 5 minutes after being told he was under arrest. Constable Ellis described the alleged assault on him thus. He had tried to ground Mr. Duncan by grabbing his left leg, and ground essentially means they're trying to throw him onto the pavement here. While he was bent over for that purpose, he felt a pull and a push on his back. At this point, Mr. Duncan was off to Constable Ellis's right, and Constable Pilkington was to the right of Mr. Duncan. Later, when they were up by a fence near the back door of the building, Mr. Duncan was swinging his arms. Mr. Duncan ignored a warning by Constable Pilkington that he would be tasered, and he was, in due course, tasered, taken to ground, and handcuffed. In cross-examination, Constable Ellis said that he and his partner were directly behind Mr. Duncan when he failed to signal. Constable Shane Secord is an officer in the NRPS Technological Crime Unit. He let in evidence a YouTube video of the interaction between Mr. Duncan and the police that Constable Pilkington had brought to his attention. Given the darkness, the video was of very poor quality and not particularly helpful. So this would have been likely Mr. Duncan posting this video to YouTube. Talk to your lawyer before you go ahead and post, if you have video of you being arrested or the like, talk to your lawyer before you go ahead and post it, because your lawyer may have thoughts, because here they at least tried to use it as evidence against Mr. Duncan, but the video was not very good, apparently. Of course, Mr. Duncan didn't have a lawyer. These sorts rarely do, because a lawyer isn't going to make arguments that just aren't going to work and that have no basis in law. We have an ethical obligation not to present garbage to the court. And so sometimes people want you to make arguments that are not known to the law, and we can't do it. Sorry. We can only argue things that might actually win you the case. So Constable Pilkington also testified. He generally confirmed Constable Ellis's description of the events surrounding Mr. Duncan's stop and the request for identification. However, Constable Pilkington's description of Mr. Duncan's allegedly assaultive behavior went beyond that described by Constable Ellis. By Constable Pilkington's telling, early on Mr. Duncan tried to push both him and Constable Ellis and was kicking at both of them. Then, when Constable Ellis was bent over to grab Mr. Duncan's leg, Constable Pilkington had a better viewing angle and, understandably, could actually see Mr. Duncan grabbing Constable Ellis's body armor from behind. Constable Pilkington responded by grabbing Mr. Duncan off Constable Pilkington, and they all continued their dance toward the back door of Mr. Duncan's apartment building. Constable Pilkington said that Mr. Duncan tried to grab his taser, but Constable Pilkington kept him away from it, and Mr. Duncan continued resisting. Incidentally, going for an officer's weapon is a very bad idea. The courts tend to punish that very harshly. According to Constable Pilkington, Mr. Duncan then got away from him and Constable Ellis, and Constable Pilkington moved in behind Mr. Duncan. From that perspective, Constable Pilkington saw Mr. Duncan kicking towards Constable Ellis and had his fist raised in the air in a haymaker position and swung it at Constable Ellis. In response to this, Constable Pilkington said that he drew his taser, removed the barbed cartridge, and stunned Mr. Duncan with direct contact between the shoulder blades. This caused Mr. Duncan to go to ground, whereupon he was cuffed, although, according to Constable Pilkington, he continued to struggle after being handcuffed. It will be noted that there are some discrepancies between the versions of Constables Ellis and Pilkington. Constable Pilkington makes no reference to warning Mr. Duncan about the use of the taser. Constable Pilkington refers to substantially more assaultive behavior than Constable Ellis, including the raised haymaker towards Constable Ellis, who Constable Pilkington believed was actually face-on to Mr. Duncan at the time of this significant punching motion. These are arguably not trivial discrepancies, although they may reflect the inherent differences in two people seeing the same event from different perspectives. So, there's a lot going on there. I mean, this might be a credibility issue, or it might simply be that people don't remember events perfectly. Whenever you get multiple witnesses to the same event, some people see some things, some people see other things. They have different remembrances as to what details they remember when they're telling the story. So it's hard to know what to make of this. I didn't see these officers testify, so I don't know what's going on. Constable Pilkington specifically testified that the reason for the traffic stop, which led to the demand to identify, which led to the arrest for failure to identify, was the failure to signal the right-hand turn. We did not finish Mr. Duncan's trial on the first day. As I left court that day and contemplated returning in the autumn to finish the trial, it occurred to me that I would have to write rather a lot to address the various procedural issues raised by Mr. Duncan in his tome and verbal arguments. Now, don't get me wrong about this. I'd be happy to write until the cows come home about matters of substance relating to the guilt or innocence of the defendant and the liberty interests of a citizen vis-a-vis the constabulary, but the idea of having to disentangle all of the palaver, nonsense, and gobbledygook in the document Mr. Duncan presented to me was not particularly appealing. That, I think, is a fair description of how the courts have typically handled these kinds of arguments. Palaver, nonsense, and gobbledygook. And I know I'm going to get angry comments in the comments. I know it. I'm probably going to get some hate mail over this one, but really, there is no merit to these kinds of arguments, and people try them all the time and they fail. But we'll see how things go here. So, the gods are kind. There's an ancient proverb to the effect that those whom the gods would destroy, they first make mad. The prospect of disentangling Mr. Duncan's adopted argument and his volume of internet-derived gibberish made me wonder if, for some reason, the gods had me in their crosshairs. This concern, however, was dissipated in mid-September 2012 when the gods made their benevolent nature clear. If December 7th, 1941 is a day that will live in infamy for anyone faced with Freeman on the land or similar litigants, 18th September 2012 is a day that will shine in virtue. And there's a footnote there. I should note that Mr. Duncan said on the second day of trial that he did not consider himself to be a freeman on the land, although his approach did seem to share a lot in common with theirs. Nothing hinges on the application of a particular label to Mr. Duncan's litigation strategy, as is made clear in the Alberta Queen's Bench decision of Meads and Meads, to which I refer later. Remarkably similar obstructionist litigation strategies come to court with hugely divergent labels. With his whole life ahead of him, one can only hope that Mr. Duncan will not only eschew formal adherence to that line of thinking, but will forsake all of the odds and ends and bits and pieces that accompany it and similar silliness. All right, so they say, on that day, Mr. Justice J.D. Rooke, the Associate Chief Justice of the Alberta Court of Queen's Bench, delivered a judgment in the matrimonial case of Meads and Meads. Given that the judgment weighs in at a mammoth 736 paragraphs, there's a reason I'm not covering it, right? 736 paragraphs is a lot of text. I wonder if these litigants are perhaps more prevalent in Wild Rose country than they are in Ontario. Be that as it may, Justice Rooke's comprehensive judgment on what he labels organized pseudo-legal commercial argument litigants of various iterations wonderfully frees me from having to address any more effort to the jurisdictional arguments raised by Mr. Duncan. As I've said, there's a lot of patent rubbish on the internet. If Mr. Duncan wishes to while away a few hours more productively on something that actually makes sense, I commend Justice Rooke's judgment on canley.org to him. And I'll link it in the description below if you guys want to check it out. It is a long, long case. In terms of why Justice Rooke went through it, there was a period of time when we were seeing more and more of these sorts of arguments. And I think that's died off quite a bit, in large part because of this decision. Justice Rooke took the time to basically go through a lot of the arguments and slaughters them. He just really goes to town on them and basically commends to the court an approach of dealing with them, which this case seems to be following, which is basically to say, listen, you don't have to give these arguments any credibility. You don't have to address them beyond simply noting that these, what they are and dismissing them. There's actually various advice in terms of, costs, in terms of potentially having people declared vexatious. There's directions to lawyers that we are not to, go along with this sort of gobbledygook, as the case puts it, or silliness. So the Meads and Meads really put a nail in the coffin of a lot of this, and so it's actually seen a lot less often, at least here in Alberta courts. And probably this sort of thing is why. The courts are less likely to entertain it, and when these things sort of get dismissed out of hand, it tends to discourage them from being brought in further. So there is no merit to Mr. Duncan's jurisdictional argument. Such arguments are a waste of the court's time and resources, a selfish and/or unthinking act of disrespect to other litigants, and deserving of no further attention, energy, or comment. So the court says, we're not even, that's it. And I think that's fair. I mean, when somebody comes to the court with nonsense, there's no real need to pretend that it's anything but nonsense. Now they move on to, has the Crown proved the charges beyond a reasonable doubt? With the distraction of the jurisdictional issues now safely off stage, we now have the luxury of focusing on old-fashioned notions like the merits of the case. I love the snark on this one. Old-fashioned notions like, has the Crown proved its case? Indeed, even before Justice Rooke's gift to the judiciary, when we broke at the end of the first day of the trial in July, at which point the Crown had closed its case, I suggested to the self-represented Mr. Duncan that he might want to use some of his internet skills to look at the actual issues related to the question of assault to resist arrest in the context of a Highway Traffic Act investigation, since it seemed to me that a defendant with counsel might be inclined to advance a non-suit motion in response to the evidence I'd heard. So, to break down what this is saying is, so a non-suit motion is essentially that the Crown's case is so bad that a reasonable judge or reasonable jury could not convict on it. Typically, that means that they have in some way failed to even provide any evidence on a critical element of the offense, but it's not necessarily limited to that. So what he's saying is he's telling Mr. Duncan, listen, the Crown's case is real bad. Maybe you want to just argue that the Crown's case is real bad, and then instead you could win on an actual argument that exists. Wouldn't that be nice? And I doubt that happened. So let's continue on. So when we returned to continue the trial, before calling on Mr. Duncan to announce if he was calling a defense, I asked the Crown to comment on whether or not there was a case to meet. So this is the judge being extremely generous to Mr. Duncan, because when we're talking about whether or not there's a case to meet, Mr. Duncan, if he decides that he wants to call a defense by testifying himself, for example, might actually improve the Crown's case. So the justice here is telling the Crown, listen, do you think you have a case, or are we done here? Which is really a bit of a gift to Mr. Duncan. I asked this because it seemed to me that whatever evidence the state might theoretically have possessed, the evidence as articulated at trial was seriously deficient. It also seemed to me that the case was based on an incomplete understanding of the Highway Traffic Act, i.e. that in the words of another, more ancient Matthew, the Crown's case was a house built upon sand. After hearing from the Crown, I dismissed the charge against Mr. Duncan with more detailed reasons to follow, these being those reasons. So it looks like the Crown probably agreed that maybe they didn't have the case there, or maybe the Crown didn't, and the justice just said, I don't want to hear from you, Mr. Duncan. Please don't blow your own case. You're self-represented. I'm going to do you a real big favor, and I'm going to spike this. So I don't know whether the Crown, it's not clear here whether the Crown was saying, yeah, we're done here. But Mr. Duncan wins. He wins this case. But he wins it on the law that actually exists, which is that the Crown has to prove that the offense happened and not some arcane mumbo-jumbo here. So it is self-evident that a charge of assault to resist arrest requires proof of a lawful arrest. This is not a charter issue. It is a fundamental element of the offense. So what that means is that in order to convict you on resisting arrest or, charges to that effect, the arrest itself has to be a legal arrest. An unlawful arrest doesn't carry any special power. If a police officer is arresting you unlawfully, it's about the same as if a hobo is arresting you unlawfully. You are entitled to resist an unlawful arrest. That said, it is almost always a bad idea because first thing, Mr. Duncan got tasered. That's not a whole lot of fun. And that is among the lesser injuries that you can imagine people sustaining in these things. And second, you got to be sure you're right. And you are often going to be wrong about that because the police may, in fact, have good grounds to arrest you, even though you don't think that they do. Sometimes these will be things that exist only in the mind of the police officer that won't have been communicated to you. Somebody might have robbed a bank just a short distance away, and they might have looked exactly like you. Your mysterious doppelganger has robbed the bank, and that might mean that the police have very good grounds to arrest you because you look exactly like that person who robbed the bank. So resisting arrest is a very risky, at best, and ill-advised thing. That said, after, when we get to this trial stage, it becomes a thing that the Crown has to prove, is that it was a lawful arrest. So the requirement reflects the important fact that in a democracy, agents of the state operate within limits. If an arrest is unlawful, resistance to that arrest is not unlawful. There are relatively few offenses under the Highway Traffic Act for which the police have a power of arrest. Caution, this varies dramatically depending on which province, and at this point, this is a 2013 decision. It's fairly old. I haven't looked up the Highway Traffic Act in Ontario to see if this has changed, but lots of places have made it easier for police to arrest for Traffic Act offenses. So don't go looking at this and saying, oh, great, because you might not live in Ontario and you might not live in Ontario in 2013. So big cautionary flags on that one. In the present case, the purported underlying arrestable offense committed by Mr. Duncan was his failure to identify himself under the Highway Traffic Act. In turn, his obligation to identify himself must be based on a lawful exercise of police power, in this case under the Highway Traffic Act. While there may be other lawful foundations for a police demand for a driver to identify himself, the only one articulated in this case was Mr. Duncan's failure to signal his right-hand turn, which would allegedly make out an offense under Section 142 of the Highway Traffic Act, again, of Ontario. The problem with the Crown's case is that it is not an offense merely to make a turn or lane change without signaling. That is not what the Highway Traffic Act says. Rather, the Highway Traffic Act provides a materially narrower offense as follows, and again, 2013, I haven't checked if this is current. The driver or operator of a vehicle upon a highway before turning to the left or right at any intersection or into a private road or driveway, or from one lane for traffic to another lane for traffic, or to leave the roadway, shall first see that the movement can be made in safety, and if the operation of any other vehicle may be affected by the movement, shall give a signal plainly visible to the driver or operator of the other vehicle of the intention to make the movement. Note the bolded part. If the operation of any other vehicle may be affected by the movement, shall give a signal plainly visible. We'll come back to that in just a moment. On the evidence led and articulated before me in Mr. Duncan's trial, there is absolutely no basis for me to conclude that the operation of any other vehicle might have been affected by Mr. Duncan's allegedly unsignaled turn. Neither officer adverted to any impact on them by the alleged failure to signal. Neither did they refer to any other vehicle being affected by it. Indeed, there is no reference whatsoever by either of them to the presence of any other vehicle anywhere close to them, and no rational basis for me to conclude that there even were other vehicles nearby just before 3 a.m. It is a fact of life that the Highway Traffic Act often serves as the gateway into many more serious criminal investigations, but it is not carte blanche for all purposes. Here the police purported to rely on a specific provision of the statute that they either failed to appreciate what the statute actually requires or failed to explain how the section was engaged by Mr. Duncan's alleged behavior that night. As I've said earlier, there may be other provisions in the Highway Traffic Act that the officers could have relied upon to stop Mr. Duncan, but none was adverted to. So, what does this mean? Well, in order for this to be an offense, there had to have been some other vehicle that could have been affected by Mr. Duncan's turn. And that could have included the police vehicle. But the police are required at the trial to actually articulate this. They have to demonstrate that he committed the offense. And so had the officers testified, listen, we were 30 feet behind him, we had to brake for his turn, so, we were affected, then that would have been enough, most likely. But they apparently didn't do that. So they didn't prove the case, and Mr. Duncan wins. Now you might say Mr. Duncan is getting off on a technicality here, but the technicality is the Crown or the police didn't do their jobs. They didn't successfully prove the case, so he's entitled to be acquitted. So, yeah, on actual law here, Mr. Duncan walks. If no lawful basis for the stop has been articulated, there was no lawful basis for the demand for identification. If there was no lawful demand for identification, the arrest for the alleged failure to identify was unlawful. If the arrest was unlawful, assuming that Mr. Duncan resisted as described, he was entitled to do so. Applying the test for a non-suit, given the absence of evidence of a lawful arrest, there was no evidence before me upon which a reasonable trier of fact, properly instructed, could find Mr. Duncan guilty of the charge of assault to resist arrest, so I did not call upon Mr. Duncan to advance a defense. So you see how this snowballs. Because the stop had to have been lawful, and they say, well, the Crown hasn't proved that. Then the next thing is the demand for identification lawful? And that depends on the stop being lawful. So that break there continues to affect the demand for identification. And then when that's not lawful, the arrest is unlawful, which means he can fight back, because this is basically just these officers, if they're engaged in an unlawful arrest, they're basically treated as if they are two random dudes who happen to be going after Mr. Duncan. And this is actually kind of a self-defense case, believe it or not, in a very weird kind of way. It's not really a self-defense argument, But they do note that he is entitled to resist this force. He's entitled to defend himself here. So, and they, as they said, didn't call upon him to advance a defense, which is a bit of a kindness, because if you're a lawyer in this situation, they will ask you, the court probably won't tip you off that you can non-suit. They'll probably just ask you and invite you to potentially blunder into it. So a good lawyer here would, of course, have spotted this and would have made their own argument, but here the court is kind of doing Mr. Duncan a kindness, which from the sounds of it, maybe he didn't deserve given some of his other arguments. But this justice is really treating him fairly, notwithstanding the fact that there is some clear and evident sort of snark aimed in Mr. Duncan's direction. The justice treated him quite fairly in terms of this decision. So, conclusion. Near the beginning of his comments to me at the outset of this trial, Mr. Duncan proclaimed that he had no obligation to produce identification to the police officers. In that moment, before he continued down the Alice in Wonderland garden path of trusts and jurisdiction and dollar amounts and contracts and natural persons and administrators, Mr. Duncan momentarily hit upon the concept that would ultimately lead to his acquittal, albeit not by the rather circuitous and, with all due respect, silly path he wanted to go down. Applying the rather more prosaic concepts of the element to the offense and an analysis of who did what to whom why, the only conclusion reasonably open to me on the evidence of this trial was that the police and Crown failed entirely to articulate a lawful foundation for the attempts to arrest Mr. Duncan. And there's a footnote here. I shall leave for another day the question of whether or not Mr. Duncan did fail to identify himself. There's obviously the unclear factual question of whether or not he was properly asked to identify himself in any of the manners acceptable under the Highway Traffic Act. See the decision of Rosenberg J.A. in The Queen and Plumber, 2006. There's also the question of whether, in proffering his red binder, both officers refused, but which contained documents identifying himself, Mr. Duncan had in fact offered proof of identity. I'll talk about that again in a little moment here. The evidence before me failed to demonstrate that the purported arrest of Mr. Duncan was lawful. A citizen is entitled to resist an arrest that is unlawful. Thus, even assuming that I were to accept the police evidence of Mr. Duncan's actions as making out the assault beyond a reasonable doubt, an issue that is not entirely free of controversy, a non-suit and thus an acquittal is the only outcome that is lawfully open to me on the evidence before me. Mr. Duncan is entitled to his acquittal, and none should begrudge him it. In assessing how much of the Freeman on the land type of philosophy that he wishes to adopt in future, a philosophy that appears to focus on to an unhealthy degree on freedom from societal obligations, he might, however, wish to contemplate some more productive reading on the internet, reading which emphasizes the importance of responsibilities as much as society's ongoing and sometimes exclusive fixation on rights. I don't necessarily agree with this bit. Rights are important, and I act to defend rights. That is, I think, critical. However, you've got to defend rights that actually exist, not ones that you just made up. So none of us is the center of the universe, or as best expressed by John Donne, no man is an island entire of itself, every many is a piece of the continent, a part of the main. Mr. Duncan did not strike me as a fool, and individual acts seldom define people, but the red binder he offered to the officers and the affidavit of truth he offered to me in court were regrettable descents into foolishness, and Mr. Duncan would be well advised to be more discriminating on what parts of the internet he models himself upon in the future. And so the decision was released on March 26, 2013. Now, I said I'd come back to the red binder. There's another case, and I can't remember the name of it, where somebody was acquitted because the officers had failed to have any look at all at the contents of a similar binder that was handed to them. And so they basically said, well, it could have had ID, so you can't convict him for not having the ID if it could have been in there. So, yeah, that's, again, though, a substantive argument on real law that ends up being brought about by the unique circumstances of what that particular individual did. So as we can see here, the court did not have any time or patience really for the sort of Freeman on the land arguments. They basically say, this is garbage and we don't have to listen to it. We don't have to, even give it any, we don't have to pretend it's anything else. But he still walks because, notwithstanding the fact that I'm sure this guy was getting on the court's nerves, the court still is going to apply the actual law. And the actual law here says the Crown failed to prove their case. They screwed up. And, well, I can't say, that it was the Crown necessarily that screwed up, or, perhaps the officers, and, perhaps more likely the officers screwed up because either they failed to articulate the, in court, the basis for the arrest, which is pretty much a basic testifying skill if you're an officer, is, this person actually made out the offense that we arrested them for. That's an important thing to get out. Or maybe he didn't actually commit the offense. Maybe he carried out an act that is similar to the offense, but wasn't actually the Highway Traffic Act offense. So yeah, this is, I think, a good example because A, it's a funny case, and funny is always a good thing, but B, I think it really illustrates the approach that courts have been taking with respect to a lot of these arguments since the Meads and Meads decision, which is basically sort of a quit your bullshit kind of thing. Thanks, you've got these long, complicated arguments. Quit your bullshit, let's move on and deal with this with some actual law. As I said, I know I'm going to get some angry comments on this one because some people are really big believers in this. They really buy into these kinds of arguments. And I can see why. They're tempting. When somebody comes up and says, hey, listen, I've got this sort of magical formula that you can use to get out of all sorts of problems. You don't have to pay taxes. You don't have to register your vehicles. You don't have to whatever. People are really inclined to believe that. They're really inclined to think that they've found some secret way of navigating the court system. But it's a fiction. It's not a real thing. It doesn't help people. And I have seen some people very badly hurt by having bought into these notions because they end up getting themselves into trouble that's often very difficult to untangle. Mr. Duncan was lucky here. Something went wrong with the Crown or, police's case and they couldn't prove it. But let's imagine that, the officer had just said one more sentence, because that's really all that it would have taken here is, a couple of sentences in that officer's testimony. Mr. Duncan might well have been convicted. And that's a fairly serious charge to get convicted of. He's a very lucky man at the end of the day. Anyway, I guess that's everything for today. I'm going to be shortly this weekend going to my first ever 3-gun match, so hopefully I'll have some footage of that. I'm going to try to bring out the GoPro and get some footage of that. If you happen to be in the area and you want to come out, the Battle for Alberta is going on. You can watch me come and probably really suck at something, which, I mean, that's kind of part of life. You got to go out and do things that you're going to be terrible at, either to get better at them or just because you want to do them anyway. Anyway, thank you for watching. I hope that this has been useful. Please like this video. Please share it with your friends. Please subscribe to see more content. I suspect I will have some people who are angry about this one, but oh well. I also want to thank my Patreon supporters at the $50 level, Jonathan Wheeler, Jason Elliott, Canada's National Firearms Association, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, and Andrew Elsich. I also want to thank everyone at the $10 level who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.